Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 189 of the NCDWI Guy podcast. On today's episode, we are talking about how to depose an officer. How to depose an officer. Now, before we get rolling here, you may be thinking to yourself, what the heck is Jake Minnick talking about? You don't have any statutory right to depose an officer in district court. So what are you talking about? How to depose an officer? Well, we're going to answer that question, work through what I mean by that. But it is something that I think we underutilize as a defense bar. So we are kind of continuing this series regarding discovery that I began back on episode 186. 10 ways to get discovery in district court back on episode 187. We continued that conversation as well. We will be working down this path here for the next few months. We might skip a few weeks before we do another discovery episode, but we're going to continue to kind of expound upon the different discovery opportunities that I laid out in episode number 186. So go and take a listen to that episode if you have not already done so. But to dive in here, so deposing an officer, right? You wanna know as the defense lawyer what an officer is going to say, right? And so there are some ways that we can kind of figure out what the officer is going to say. We can look at the officer's notes. We can review the body camera, dash camera, and figure out what the officer said at the roadside. We can immediately, prior to court, speak with the officer and say, hey, tell me what was going on. Did you do this? How did this look? What happened on this test? I mean, you can, attempt to kind of lock the officer in to what he is going to say on the stand by knowing, the case backwards and forwards, asking him about that. But it's always a little bit of guesswork once the officer takes the stand as to what exactly he is going to say. And so in district court, it would be great to know exactly what the officer was going to say before they took the stand. This is one of the benefits of appealing a case to superior court, because all else being equal, if you have tried the case in district court, you have locked in the officer's testimony because the officer has already testified under oath. It's very difficult for an officer to kind of change the story. If you're doing it right in district court, if you're getting a recording of what's happening in district court, it's very difficult for the officer to kind of change the narrative in superior court. So there's a proper way to do that. Maybe that is a good meat for another day's episode. But that's one of the benefits of being in superiors. You've already heard what the officer is going to testify about. So one of the things that is typically difficult to do is have an officer testify under oath about your case prior to trial in district court. How do you do that? Is it possible to get a deposition? Well, maybe not by that name, not a criminal deposition of the officer, but there is a way to get officer testimony in certain situations. And the most prevalent of those is a refusal hearing. If you have a client that has refused, their license is scheduled to be suspended for refusing a chemical test, you can request a hearing under 20-16.2 and use that hearing as a way to lock the officer into testimony under oath that has got a recording associated with it. You have the opportunity to lock in what the officer is going to say. Now, there may be a couple of other ways of doing the same thing. I had a client once that had a DWI that followed from or stemmed from a domestic violence situation. And so was charged with DWI, was charged with assault. There was a related 50B hearing that occurred in civil court. And the trooper was one of the witnesses that was called in the 50B hearing on the civil restraining order side of things. And so there was an opportunity to get a chance to hear what the officer was going to say in that civil hearing. So it may not just be a refusal hearing where your opportunity to get testimony from an officer under oath lies. There might be other related civil hearings connected to your case. If there is a situation in which your client is charged, let's say, with a serious injury, there may be a civil situation involving specific officers or other witnesses to the case that happen through deposition or something else. So again, think outside the box in terms of other places where you might be able to do the functional equivalent of deposing an officer. But again, for today's purposes, we're going to focus on a refusal situation. So in a refusal hearing, you do have somewhat of a limitation of issues. Caveat, there's nobody really objecting if you kind of go outside of these limited issues. So unless you get reined in by the hearing officer, this may not apply. But under 20-16.2D, that outlines the right to a hearing in the event that a refusal has occurred. And there are basically 5 things for the hearing officer at the hearing to occur. Whether there was reasonable grounds to believe that an implied consent offense had been committed is one of those. Whether there was an actual willful refusal, right? Whether the person was read or notified of their rights. So basically, we've got kind of like PC related issues. We've got willful refusal related issues, issues related to the way that the breath test or blood test was requested and performed. So effectively, it is relatively, even within the limitations of the statute, pretty open-ended. But while a bad stop might not be a grounds for contesting a refusal, it's not. That whether or not there was a constitutionally valid stop doesn't really play into the refusal revocation. However, it can basically be kind of something that is open for questioning in terms of what led to the stop, because that then plays into a probable cause analysis. So questions regarding the stop would be up for grabs because that could contribute to a PC issue. So, again, I think that requesting a refusal hearing can be good for a number of reasons. We're not going to go deep on this, but you can potentially timeline the refusal suspension with the suspension that could possibly come from the DWI conviction on the underlying offense. So just timing of the refusal suspension itself might be a good reason for appealing the refusal revocation. There might be a legitimate chance of winning, either based on a substantive issue or because, the trooper doesn't show up at the hearing. There is some sort of a real meaty issue on PC, let's say connected to the criminal case, and you can get a order basically that binds the DMV in terms of finding the same. So there can be a number of reasons why contesting the refusal revocation in any case may make sense. But if you got a DWI that's going to trial and the refusal hearing would happen first, you would really benefit, I would say 9 times out of 10, from having the opportunity to question the officer under oath with a recording available, where the officer then can't later, give different testimony. Now, let me kind of put out again one of the kind of like psychological benefits of doing the refusal hearing prior to doing your DWI trial. One of the kind of nice things about a deposition from, and again, different people are doing different, taking different approaches to a deposition, but, generally speaking, a deposition is not the same for civil or criminal trial purposes as a cross-examination is not the same as a deposition in terms of the tone and phrasing of questions. Generally, in a deposition, you're trying to learn information. It's a discovery tool. You're trying to kind of understand what the officer is saying. Now, at some point, you may also want to use that as a way of locking in the witness's testimony, but it is a place where kind of unearthing the facts of the case is a little bit more loose and, basically open-ended than cross-examination might want to be at trial. So a deposition in a civil case, generally speaking, is done in the room of a attorney's office somewhere. It's done in a place where, there's nice pictures on the wall. There's a conference table. Typically in a civil case, there's no judge present. It's lawyers maybe from both sides, a court reporter, water is available, snacks are available. It doesn't feel, as kind of uptight as a courtroom feels when you're sitting on a witness stand with a judge by your right. A bailiff is sitting there. There's a bunch of other people in the gallery, or maybe a jury is in front of you. The courtroom is an intimidating space. A deposition doesn't feel that way, even though it can be extremely anxiety provoking. It doesn't have that same feel, but it's acting in the same way, because once you have locked in somebody's testimony in the deposition, it really can't be changed at trial. So it kind of has the same purpose, even though it doesn't feel the same way from the witness's perspective. So, where are most of these refusal hearings done? Well, I've done them all over our area here in Asheville. And, sometimes they're at the local DMV. I've done them in a conference room at a courthouse. I have done them at State Highway Patrol headquarters. There's a number of different places where a DMV hearing might occur, but typically it's in a small office, with a desk. There's a file cabinet, chairs, pictures of something on the wall. Sometimes it's not in the hearing officer's normal office location. So it just feels like basically a, kind of conference room, or just kind of a space designated as, okay, well, anything that is going to happen here out of the ordinary, this is the room for it. And so what does that lead to? It leads to potentially, in my opinion, a relaxing of the kind of officer's mentality versus, again, being on the witness stand at trial. So it doesn't have the same, again, in my opinion, intimidation factor doing the hearing with a hearing officer in this small office location as doing it in front of a district court judge in a district courtroom with a lot of other people present. A lot of times at a refusal hearing, there's 4 people, right? There's the hearing officer, the officer that conducted the DWI investigation, your client, and you, right? 4 people. That's never going to be the case in district court. You're going to have the DA, the judge, the, there's just going to be a laundry list of people that are working through it from a court side of things. So, again, the intimidation factor is not the same. Now, when the other advantage that you have that is similar to a deposition is that generally at a deposition, if one side is deposing another side, the deposee's side may have an attorney present representing them, but the objections in a deposition in terms of what can be asked, like the questions that can be asked, responses that can be given, are relatively limited. You maybe can state an objection for the record, but that doesn't necessarily mean that the question's not going to get answered. So similarly, in a DMV hearing, if you're asking questions, the state is not generally speaking, there's certainly no DA present, but the state is not generally speaking standing up and saying objection to that form of the question, right? You're going to be allowed, unless you go like way outside the bounds of the hearing, you're going to be allowed to ask questions and there's not going to be objections, right? A lot of times there won't be any even redirect by the hearing officer about the refusal based on what your questions are. So you really are going to be given a lot of leeway, again, in terms of getting open-ended discovery by asking these questions at the hearing. So and you may have different issues that are going to be critical at trial that are not going to be really at issue under 20-16.2D for the purpose of the refusal hearing. So again, the hearing officer is basically, concerned about whether those 5 criteria are met or if they are not. And so if the 5 criteria the hearing officer has determined are met, then basically anything that you're asking, the hearing office, the charging officer at that point really may not matter to the hearing officer. However, it may matter greatly when it comes to what is happening at the DWI trial. And so because the issues are dissimilar sometimes in terms of what might be grounds for a not guilty verdict or a dismissal in the criminal case, you may kind of catch an officer unawares or be getting information from them at the DMV hearing that is not relevant to the DMV hearing issues. But again, keeping it open-ended. So I think part of it is you have to know going in what you are trying to do, what you are trying to accomplish with the hearing. Maybe it truly is a kind of discovery opportunity. You might just be asking open-ended questions about the stop, about the arrest, about how the breath test or blood testing was performed. And so you may go in just really trying to collect as much information as possible. However, I think you can also use the DMV hearing to lock the officer into their testimony, right? Trooper Smith, you indicated here on your driving while impaired report that these are the signs of impairment that you noted at the time of the stop. Were there any others? I don't remember. Are you sure about that? Take a minute to think about that. Are you sure? That's all I can remember. So outside of what you put in your report, there's nothing else that you can remember. No. Now, when you go to trial in district court, again, you know what the officer is going to say. Not because there's kind of like a guesswork or because you're doing something, kind of fancy by locking them in through testimony in district court, but you absolutely know how they are going to answer that question. And if they don't answer it the same way, assuming that you've gotten a copy of the transcript from the DMV, you have locked them into their testimony. So You kind of want to know how you're going about your questioning at the DMV once it's your opportunity to question the charging officer. Is this an open-ended search? Ultimately, what issues or items am I trying to kind of lock the officer in on at the hearing? So there's some real value to that. And again, the ability to kind of ask things that you may not be able to ask with the state being represented by the district attorney objecting to questions in district court really gives a massive advantage by doing this at the DMV hearing. You can get a copy of the DMV recording following the hearing. And I'm happy to kind of walk anybody interested through that process. It's a relatively simple thing to do post hearing. Again, assuming that you're you actually put a refusal hearing request in and actually sit down and have the hearing. It's a relatively simple process post hearing to get a copy of that recording, which you can then use in cross-examination to impeach what the officer is going to say. So there's a huge value to that. Now, one other benefit, I think, to doing a refusal hearing, and this is, I would say, particularly for a client that, is just of the opinion that, I also think that because let me just back up for 1 second. I think another value point that you have when you do it this way and then take a case to trial in district court is that a district court judge is going to notice a level of preparation on your end when you are asking questions like this at trial. Trooper Smith, do you recall on April 7th when we had a hearing in front of a hearing at the DMV on this issue? Did you testify under oath at that time? X. Did you testify under oath at that time? Y. Think how rare it is in a district court trial to hear those type of questions getting asked by a defense lawyer. We might normally say, Officer Smith, isn't it true that you never saw this? Or Officer Smith, isn't it true that on your report you didn't notate that? But it's way more powerful. I mean, like insanely more powerful to say, didn't you already state under oath that you didn't see that? Right? Now, not only is it a more powerful piece of evidence, but I also think that the judge is taking notice that, look, this lawyer over here has already been in this back and forth exchange with the officer prior. The lawyer's done their homework. In terms of separating yourself from the state that's not had an opportunity to examine the officer prior to the district court trial, you are in the lone position of people in the courtroom to basically say, we've already had a hearing on this, judge, and here's what the officer said at that hearing. It just gives a different level of authority to the way that you are framing your cross-examination questions at the district court trial. So sorry for that kind of that sidetrack. But the last point that I wanted to make on this issue is that it's a powerful tool. Going in front of a refusal, going in for a refusal hearing and seeing the trooper testify is a powerful way to assess the weaknesses of your case as well, with the client having the ability to watch. So if you have a client that is pretty geared up for trial, the state violated these rights, the state, the officer didn't ask me X, Y, Z, the officer, didn't do this or that, whatever the kind of client is kind of thinking in their mind. if you have a case that is not good for district court trial, it's not going to be a good case. And potentially the facts of the case, if they come out as they will through trial, could be damaging for sentencing. Going through the refusal hearing process can be a good way of showcasing or previewing the evidence to your client in real time. Okay. We're not now just saying what I believe about the officer's report. We're not now just saying what I have kind of like witnessed by looking at the video, the body cam, whatever it may be. Here's what the officer is going to testify to in court. And it's going to come out. It's going to come out very similarly to how it just came out. You heard it from the officer's mouth. You know what is going to be said. This is going to be a problematic situation for us. I think it can be very powerful for a client that is, again, really pushing for a trial. And ultimately, it's their decision if they want to take the case to trial. But if you have concerns about how the facts are going to play out at trial, not only in terms of not having a good chance of winning the case at trial, but are going to be an issue for you in sentencing, then having a preview of the trial for your client to witness in real time may be helpful. And then kind of thinking through it and saying, you know what, my attorney doesn't think this is a good case to take to trial. This is going to be, I've seen what the officer is going to say, I'll go ahead and enter a plea. And ultimately, again, that's up to the client. But in terms of trying to provide good advice, I do think that especially if you're seemingly going to war for your client, and not seemingly, if you're going to war for your client in the refusal hearing and they see that, and it's clear how the officer is going to testify. Again, I think that can really just be a powerful thing for the client to observe in terms of making that decision. So again, there's a number of reasons why pushing a case to a refusal hearing makes sense in terms of license protection, getting the biggest bang for your client's buck in terms of shortening the overall period of license revocation, having the opportunity to lock in the testimony of the state, having the ability to have your client see a kind of preview of the testimony that is going to be given at district court, a whole number of reasons. But I think that refusal revocation hearings are grossly underutilized, generally speaking, because of this mindset. I'm not going to win. My client's not going to win the refusal revocation. I don't see any way that the hearing officer doesn't find that the requirements under 20-16.2D have been met. We're not going to win at the refusal hearing. So what's the point? There is a lot of value in contesting the refusal, even if it's not a likely winner substantively at the refusal hearing. So think about other value points that stem from contesting the refusal. Again, we are going to continue over the coming months our kind of deep dive into some of these discovery issues, because this is where cases are won and lost at trial, in discovery. So we're going to continue this conversation, and I look forward to speaking with you again next time.